Hello everyone, my name is Fafali and I'm your host for today. You're welcome to the maiden edition of Ghana Made Lit. For this episode, we are talking about how to secure your intellectual property, particularly pertaining to the literary world. And to join me do that, I have the lovely Miss Sheila Jangma on my left. And next to her, we have Mr. Sylvanus Beja. So I'd allow them to introduce themselves and tell you a little bit, just like a teaser, of who they are. So let's start with Mr. Beja.
Ladies first. It is still ladies first.
I was expecting that.
All right, so my name is Sheila Nakijangma. I've been working with the Copyright Office for quite a while because of my interest in the subject matter. And I used to like to really read, but these days the books, the kind of books I have exposure to, I'm not able to just read as much. But yes, I do read and also sew in my spare time. I'm a graduate of Legon and Africa University, all doing Africa University. I did the intellectual property course over there.
Wow.
So just a little bit.
Wow, that's extensive. Thank you. Mr. Beja?
So I'll make mine shorter. My name is Sylvanus Beja. I am a student of University of Professional Studies, Accra, studying law, level 400. I also happen to be an executive member of the Ghana Association of Writers. I am the first Deputy National Organizing Secretary of the association. And I'm also a writer with 3 books to my credit. Yeah.
Wow. You're both welcome.
Thank you.
Thank you.
Thank you.
It's beautiful starting with the two of you because I think there's going to be an interesting conversation. You from the fact that you're an author and coming from a law background, and she all those years. Wow, that's combining that together. That's a lot of rich information that we're about to get.
Yeah.
So diving right in. Since she went first, Mr. Beja.
Yeah, still ladies first.
What do you understand by intellectual property?
Okay, so just like any other right, if you look at our constitution, Article 18 of the 1992 Constitution clearly stipulates that every human being must have rights to enjoy, and that right is actually touching on property. So now if you extend that interpretation of that particular provision in that constitution to every other aspect of our life. If you look at what intellectual property is, it is like the intangible properties that you and I cannot touch. Per the definition from the World Intellectual Property Organization, it sees intellectual property to be the creations of the mind, okay, the product of the creations of the mind that you cannot touch, okay, and they are supposed, per their definition, they are supposed to be original to whoever is creating it. So that is what intellectual property is. If you want to juxtapose it with what other properties are, you can touch those properties, you can see them, people own them, but for the intellectual properties, they are developed from the mind, and they are the result of what comes out from either creativity, ingenuity, or innovation from other people. That's what intellectual property is.
Wow.
You couldn't have put it better.
Oh, I like that. So, Ms. Jama, can you share some examples of what these properties can be?
All right, so the general term intellectual property is broken into 2. So I'll just give you all the examples that are falling under. So one part is industrial property and the other part is copyright. So under industrial property, we have patents, we have utility models, trademarks, service marks, trade secrets, geographical indications, and industrial design.
Yeah.
It's not exhaustive, by the way, but these are some of the examples. And then under copyright, we have the books, music, artwork, architectural design falling under that, logos falling under that, and then your books, your poetry, and so on, and computer software as well.
Yeah.
So these are all examples of intellectual property.
Okay, so if I get up today and I decide to do a black and white logo from the top of my head, it's considered as my intellectual property.
Yes, it is.
Okay. But then when I was doing my research for this episode, I realized that most of the sites that I visited kept talking about intellectual property rights. And you explained the property to me. I know most often rights are associated with human beings. So what are the difference? Is there a difference between the intellectual property right and the intellectual property itself? And can you add a bit of flesh to that?
Okay. So the intellectual property is the property, the intangible property itself. But then the extension of adding rights are the rights that the person who created the work or the intellectual property has, the right he has, the legal right that he has over his creation to either authorize or prohibit its use. So there are different rights for all the examples that I've already given. So it depends on what you've created. For example, if you've invented something new, a new solution to a technical problem, then that would be for a patent. You apply for a patent for that one. And then if you have a design, let's say something for a mass-produced item, let's say handbags, that will go to industrial design, you know. And then if you've written a book, then you go to the copyright side. So depending on what you've come out with, there are different rights that you can assert. But when we come down to the details, I can break it further down.
Okay. Okay, then it's good we have an author here. So let me just, because I had a follow-up question to what you said.
Yeah.
But then I wanted to direct it to Mr. Vedra instead. So as an author, what kind of intellectual protection, property protection do you enjoy?
Okay, so like she mentioned,
Yeah.
the differences between the rights and then the property itself. Rights by their nomenclature are supposed to come with some level of protection. And if you look at the purpose of the rights, we are supposed to be protected if you actually own that intellectual property. Okay. So if you go to Article 27 of the World Declaration of Human Rights, it talks about the fact that every person has the right to be protected in terms of moral rights and material rights for whatever they own, whatever they create. Okay, so now if you extend it to our laws around here, as a writer, I have that right to enjoy that for the fact that I have been able to create a content from my mind originally. Even if you go to the Copyright Act 690, Copyright Act 2005, it is clearly stated that per the definition of originality, you must own that work independently. So if I'm able to write a book and I did that writing myself and have been able to put it out there, I deserve some level of protection because I have that right. Like I said, the rights go with protection. The moment you mention right, everybody say, protect my rights. Okay, so I believe that with the kinds of laws that we have in this country, aside the national laws, there are also some international treaties that protect people who have intellectual properties. And I believe that I have been enjoying that right till now.
Okay,
Yeah.
so let's make, before you come in, let's make this, I wanted to get a point clear. So the rights, do they protect the property itself or the person who came up with the property? I don't know if you get my point.
Yeah, I get a point. Yes, so the rights actually are broken down into two. Again, if you go into the Copyright Act 2005, you realize that there are two main rights for authors to enjoy or persons with intellectual property to enjoy. The first one is the moral right, and that can be seen to be the bragging right that you have as the one behind this creation. I'm the author of this book. I'm the one who invented this. I'm the one who was able to bring this idea. Now, the second one is the economic right, which of course talks about your right to reproduce that material and sell, make money from it, and also be able to transfer ownership to someone and get money for it. So when you look at the right protects the both sides. It protects the content and then the person behind the content. Under these two categories of the rights that we enjoy, we can place, for instance, we can place the moral right under what protects the person. Okay, because that, what it means is that anyone who wants to talk about your book must cite it, or you must be given the credit, you must be acknowledged. So you, the person, is always protected through the acknowledgement. Then again, when you come to the economic right, it is about you selling the product and making money from it. So if you look at it from that angle, you realize that the two sides are all covered in there.
Okay.
Yeah.
Ms. Jama, you wanted to add something?
Yes, but he's further explained. So just to break it down a little bit, let's say he owns this book, not let's say he owns this book. So he has the moral right. He has explained it very well. And so if I want to have rights to distribute this book, I need to see him, for him to authorize me, in writing preferably, so that I know that I'm responsible for distributing this book in Ghana, about 5,000 copies, and for 3 years. 5,000 copies a year, or for the whole 3 years. It should be time-bound, territory-bound, so that the person doesn't go overboard. So I'll take that permission from him, and then I can go ahead. He may even supply me, or I can, depending on the agreement, and then he's making money from this. If it's a non-exclusive license, he can also give another license to another person who will also be exploiting the book in another jurisdiction, and he's taking money. So he can get multiple sources of income from this same work. But if he chooses to enter into an exclusive licensing agreement with me, it means I'm the only other person who can sell this book. Or even, he may even be precluded from selling it because I have now the exclusive license to sell it for that duration. So that's just to make it a little clear.
Okay, so let me just take it to the music industry, because I think most of us find it easy to relate to that. So if I get you right, with the example you just gave, if I come up with my own music today and I sell it to a record label, if I decide to give them an exclusive access and sell it off at one time, not having any rights again, it belongs to them. So even though I am the creator of that content or that music, I can't in the future go back and say it's mine, so I'm securing it, or I'm doing something about it.
Okay, that's an important point. Okay. Because then you have the moral right and the economic right. The moral right exists in perpetuity. You cannot transfer it to anyone. So it's just like biologically, the fact that you are the mother of a child, that it cannot be changed, or you are the father. It's also called the paternity right. So it's like paternity does not change biologically. And so if you have created the music, you are the creator. Every time the music is used, your name goes with it. This is a record by you. And then if it's going to be exploited, depending on your agreement, if you've sold it off, then that's it. You can't go back and say you want to. So it's preferable to do a non-exclusive license. Unless, for some special reason, you really want to sell it off and then go off and do something else, then that is fine. But once you've sold it off to them, your right to be mentioned will be there. But the economic gains, you will get some subsidiary rights though, but it won't be as much as if you had the opportunity to license it to different sources. So they will be exploiting it. That's the term we normally use. They will exploit it and give you something, but that's in a way of royalty. But if you've sold it off, then that's it. You get your one-time payment, and then you're gone.
Okay, so let me take us back again to the book industry. Okay. So we've heard of a lot of free ebooks, free books, and all those things. So in this context, as you're explaining what intellectual property rights is, how to protect it, how to, the moral side of it and all, how do free ebooks come in? So is it that the person has, because most of them are not even being done by a publisher, some are self-published. So did the person just get up and say, today I'm giving the world a free gift and just give it away? Or what's the legality behind all of that?
Okay. Now, with those, if it's being put out there by the author himself or herself, it's for the purpose of helping society in general. You can do that like the Creative Commons. You can intentionally give out your work so that it will benefit other people. People will also build on what you have put out there. It's just like in the software industry, they also have something where open source, you can go in and add a little, you can upgrade it a little, but you can't say it's yours. It's just there for development. Other people will come and build on it until such a time when it can no longer be built upon. So putting it out there yourself is one of the rights that you have as an author. Making available, we call it, or communicating to the public. So once you have intentionally put it out there, it's within your rights to be able to choose to put it out there to benefit the larger society.
Okay. Wow, that's good. So thank you very much, Ms. Dama. So my next question, I don't know who to direct it to, but let me just throw it out to the two of you. How do you determine the value of intellectual property? this question came up because you gave an example earlier, talking about I can give if it's a book, I can give it to a publisher for 3 years, and then after that comes back to me and all that bit. So if I have this draft or this manuscript sitting on my shelf, how do I determine the value of that?
Okay. With books, literally, the publishers have a way of calculating how the market value would be. But if we, as we mentioned, other forms of intellectual property, there are different methods of calculating how much it is worth. Sometimes you just compare it to something that's already on the market and then see how much it is. It's really a case-by-case basis because there's no hard and fast rule, even though there are different methods that you may employ. Like, you can also look at the cost method. The cost, how much did you spend when you were creating it, including things that you didn't succeed on the way. Maybe you were writing your first manuscript, didn't work out well, you thought that you did another one. All that, the cost, your time, your energy, everything that you put into it. In copyright balance, we say skill, labor, and judgment. All that have gone into it. So the sweat of your brow, they call it. So you would have to, you being the owner, you know what went into it. You can value it, but to make it more effective in the book industry, the publishers have a way where they calculate the market value based on what's in it, the number of pages, and so on and so forth. Then they can, based on that, negotiate with you how much. But you, the owner, must have a rough idea of what the cost will be. And then when you get into the negotiation with your publisher, then you can come to an agreeable term that this is how much it's going to cost per book for this number of years. Having said that, let me just continue the example I gave of him licensing the book to other people. So at the end of the period, the rights will revert to him, and he can choose to give it out to another person or not, or just retain it and then just keep selling the book as we go along.
Okay.
Yeah, so I mean, to add to that, it also largely depends on the uniqueness of the content that you want to give out to whoever. Sometimes, for instance, like a book, there are so many books around. Two people may present a book to a publisher. The publisher might find one of the books more valuable in terms of how interesting and how educative or how sellable it is per the content of the book. So it also depends on how unique that particular idea is. Talking about ideas, I think it is also very important for us to mention again that when it comes to what copyright law protects, we must make the point that it does not protect ideas.
Concepts.
In as much as the idea is what developed into the content becoming the intellectual property. The laws do not extend the protection to the ideas. And I'll give you a typical example of what happened in Ghana here in the case of Pearson Education Institute versus Morgana J. It's a very typical case where an author's book was selected by WAEC to be used by junior high school students, and about 450,000 copies of the book was ordered. Then another author, who happens to be Gateway Publishers, okay, they now copied part of the book or summarized part of that person's book, and the title of the book is The Woes of the African Mother. They put it in their book and sold. Now, the author of The Woes of the African Mother sued the publishers of the Gateway to English for junior high school students for the fact that they used his book and sold out because they picked part of the book, and that has actually contributed to him losing money. So imagine 450,000 copies of your book has been ordered. Somebody just came to summarize the whole book and even added questions. Now they depended on that particular book and couldn't buy your 450,000 copies. The court, of course, the Supreme Court, whatever they say is final in this country, unless they would want to do judicial review. They were of the view that the copying or the summary of part of that book is not a crime. It is not against the laws because it is just an idea. I mean, this is one of the judgments that I'm sure we can talk about, because if you look at the examples of what constitutes copyright in Section 1 of the Copyright Act, you realize that there's one of them that is stated to be derivative works.
Yes.
So what it means is if I take this work and I derive something from it, it is supposed to be one of the content that is supposed to be protected. So we don't understand why ideas like what happened in that case happens to go that way. So that is why authors must be very careful. Okay, what it means is that anybody can get up in this country, pick your product and try to derive something from it, maybe a book especially, and the person can go free. So we'd have to look at that.
But it's important for the person to seek authorization from the person. Had he sought permission or authorization from Pearson, they could have come into a certain agreement.
Yes, that is a co-right ownership.
One would have helped, and everybody would buy that.
Exactly.
And it would save both of them the trouble. But because they didn't make any effort to seek authorization, that's how it happened that way.
Okay, so what would you advise? Would you advise that, let's say, me, I'm an upcoming author, I have my manuscript, would you advise I register it with the intellectual property office, like the copyright office first, before now going to seek publishers to sell it to? Or I get my publisher, I sign my deal before I now come and register it?
Okay, it works both ways, but usually people are more rest assured when they have brought their manuscript to register. Even though copyright internationally doesn't need any formality to get the protection. You get it automatically upon creating your work.
Yeah.
However, to make litigation easier, if you have some records that you have indeed registered it, then you have some backing. But it doesn't also mean that registering it first makes it yours. There's a difference. Industrial property, first to file, it's yours, even if you stole it. But in copyright terms, even if you come first and another person also appears with the same application, then both parties will be called in for a mediation to determine who the work belongs to. Alternatively, they can go to court, settle it, and then the office will act on the ruling of the court. So before you send it, you may have an agreement with your editor so that you know that these are the terms of editing. So if I find my book somewhere on the shelves when I have not even completed mine, then you know that you are responsible for that. So the terms and conditions should apply in this one too. But we do accept the manuscripts for registration for the same purpose, so that if you mention to your editor that you've registered it, probably there's the likelihood that he will not try to do anything funny. So you register it, and then you go ahead and give it to him. Even with that, you can add an agreement. It doesn't spoil anything. And then after your work is fully finished, completed, and printed and published, then you can come and swap the copies with the manuscript that you gave us so that we have the final work.
Okay, so to add to that, she mentioned that the registration is not actually compulsory. If you look at the Act, Section 39, it clearly states that you may deposit 2 copies of your book. So when the law says may, it means that it's not compulsory. The law goes on to say that the protection of your work is not dependent on registration. What that means is that if you have a book, whether you have registered with copyright office or not, it is automatically protected. Okay? And so the registration, even though it's not compulsory, you are advised to register for 3 main reasons that are actually mentioned in the Act. Of course, for record purposes, to also make a point of ownership, and of course for the fact that, exactly, yeah, so it is also very important to do that. In as much as it's not compulsory, you are strongly advised. I'm sure if you should go to court over issues of copyright, it becomes more easier for you if you're able to produce a copyright certificate for your work. So people shouldn't look at the fact that it is not compulsory to avoid registering with the Copyright Office.
Okay, just to also clarify something. With the industrial property, that's when you need to register. So these are the 2 branches. One has to be registered to get the protection, but the copyright is the easier side where you don't necessarily have to, but you are strongly advised to do it.
What are some examples of the industrial one?
Okay, so the industrial property is, let's use trademark. That is easier.
Yeah.
Okay.
So trademark, the symbol for Goethe-Institut could be registered as a trademark, because that is the symbol that when you see anywhere, you know this is for Goethe-Institut.
Okay.
So that's, you put in an application at the Registrar General's Department, and then they go through a search first to check whether somebody has already registered something like that. If not, then they process it, they publish it in a journal for about 2 months to see if anyone will file an opposition that he doesn't agree. If nothing goes wrong, they go ahead and complete the process for you, and then you have rights to use this symbol for all your branding anywhere. It could be on clothing, it could be on the building, it could be anywhere, but that symbol is yours to use, but it's renewable every 10 years. So that's an example.
Wow. That's a lot to take in.
So with the industrial property, it's a renewable stuff, except the patent that for inventions, which is 20 years. You get 20 years protection in exchange for disclosing what the patent is, what the invention is.
Okay.
So for example, pharmaceuticals. So that's where when you invent a drug, you are able to have protection for 20 years. So you can recoup the money you use for research and development and all that. Then 5 years to the end of your 20 years, the formula will be given out to the other pharmaceuticals to use. So they don't go through the suffering of coming up with all the formula and stuff. They just take it. And then also create the generic drug. That's why we have the generic ones. And then the other ones.
The other ones. Okay. So you mentioned 20 years limitation for pharmaceuticals as an example and all. So I'm a bit curious. Do the rights expire, especially when it comes to the authors?
Okay. With copyright, it lasts for life plus 70 years. So the life of the author plus 70 years after he's gone. So we mentioned, and Sylvanos mentioned in the first question that let me rephrase it this way. When you create a work, you have rights in that work. So for as long as you live, you have rights in that work, unless you sold it out. Even the moral right still remains with you. And then when you die, it's a property, so you will it to your next of kin. Yeah. And so it continues along that journey for 70 years after you've gone. If there are 2 or more authors, that means the 70 years will be counted after the last surviving author dies. Before, so if there are 4 authors of a work, then unless the 4th one dies, before they start counting the 70 years. So that's a lot of years. But after the 70 years, it will fall into the public domain, where others can use and cite whose work it is.
Yeah, so to add to that, that is about authors who author books. Yes. Now, when it comes to audiovisuals and even corporate organizations or corporate bodies, it goes beyond just 70 years after death. This one looks at actually 70 years after the publication or the first time it was actually made available. Mm-hmm. So that distinction must be drawn that if it is about a book, the author is about the death of the author. Okay, so it is not, when I publish my book, it's not after 70 years, it's after 70 years that I'm dead. But when it comes to corporate bodies or the corporate organizations, and when it comes to anonymous or works, okay, yes. Or even photography, sculpture, all those kinds of... Yes, it's just 70 years from publication. So that should be made clear, yeah.
Yes. Then the authors have advantage.
Yes, that protection is there for the authors, yes. Okay. 70 years sounds like forever.
Yes, it does. Yeah. It does. I keep thinking, okay, so my dad has written a book. Now I'm calculating his lifetime. Also, after he's gone 70 years, I still count.
Like, for example, if Mamu's music is being administered by his daughter, and the 70 years is not up, so she still has ownership of it. Mm-hmm. So if anyone needs to use it, they have to see her.
They have to see her. Yeah. Wow. Okay, so when I was doing my research again, I like reading a lot. So when we decided on this topic, I went reading. I realized that there are some countries that don't have copyright laws, intellectual property rights and their laws. So just a loaded question. When did Ghana decide that, okay, we want to have our own copyright laws? And when was it implemented? Okay. How has it been so far? Okay. And the fact that I register my property here in Ghana, does that mean that if I move or relocate to Italy, it's still covered?
Okay. So,
all right. Okay. So it's been the journey of the copyright. Let me just state that. Well, the Copyright Act started from 1985. Wow. PNDC Law 110. And then it was repealed and replaced by the Copyright Act of 2005. So currently this year, we are actually starting the revision of the Act. We want to revise because there may be some provisions that we need to add in to increase penalty units of infringement and other things. Yeah. So we need to do all that. We've just revised the LI as well. And it's been a gradual journey. Okay, it's been a gradual journey. At least I can speak from the time I joined the office. I've seen there's been a gradual uphill improvement because things are looking up, even though they could be better. We're able to do our mediations as we planned. If there are any issues, people come up to us, we do the mediation, even though it's not like arbitration where it's binding, but we are supposed to be responsible for helping the parties to come to an agreement. Okay, so we've been doing that. The registration has been patronized over time, actually. Even though it's voluntary, a lot of people do come in. And even if you tell them that you don't need to register, go and finish it up and publish and everything, they feel that you're doing them a disservice. But the truth is they already have copyright. So coming to the office, they just come to notify us that this book exists and it belongs to this person. And so they didn't worry too much about the registration. It's for legal purposes though, but a lot of people come. We do have the public education programs that we do from time to time, and so it has increased awareness. Even surprisingly for the law enforcement agencies, we do workshops even for police and customs and other things, so that they understand what infringement is. If other works are coming from outside, they understand that these are infringing works, pirated CDs, all manner of things, and they know to impound those things. So all those people are in our net, and we've been partnering with a lot of stakeholders, including GAO, where I'm a regular panelist. And so, yeah, so far we're doing well. There's more room for improvement. I think that's the biggest room.
There's always a big room.
Yes, and if you register your work here, unfortunately, it doesn't cover the whole world. It's a territorial right, so private rights, and you have to enforce it territorially. So if you go to another country where there is a copyright office, you may notify them that this work exists and it belongs to you. ISBN rather makes the book visible internationally, so that can be covered. But for the copyright itself, the fact that you already have copyright and it's not the registration that's giving it to you, but in order to assert it in another jurisdiction, you need to let them know if they have an office. Not every country has a copyright office or the copyright law. So wherever you go, the rules that apply there, you would use those. But for industrial property, there's a way of registering where you designate the countries that you want it to be protected in and pay accordingly. So even if you're registering, let's say, a patent in Ghana, you can designate other countries that you want to be included in the protection, and it would cover. But for copyright, it doesn't work that way.
Okay. To add to what you said, I think that the revolution of the copyright law, like you asked, actually, you mentioned 1986, 85. So it dates back to 1961. That was when we actually have the first copyright law, before it was reviewed in 85 by the PNDC. Then we now have the 2005 Copyright Act, which was actually also reviewed in the year 2009. So if you look at the evolution, even as we speak, there's also a copyright regulation. Okay, regulation.
We've just reviewed. We were just going through validation yesterday.
Okay, so you see. So now even let's look at this laws and extend it to beyond just copyright, because like she mentioned, there are two main types of intellectual properties. So if you come to Ghana, it's the most popular one we hear about is the Copyright Act. But again, it will interest you to know that we have the Protection Against Unfair Competitions Act. Okay, we also have the Trademarks Act. We have the Industrial Designs Act. Okay, we have the Patents Act and then the Copyright Act. So all these are there to protect intellectual property. Per their nomenclature, you know what they are talking about. If you look at the protection against the unfair treatment, the unfair competition, it looks at how people can be prevented from, in the name of competition, damaging the reputation of other organizations. Okay, so if you look at intellectual property in Ghana, you can say we have come a long way in terms of the legislation to protect intellectual property as a whole. Yeah.
Okay, I like that. Earlier on, you talked about educating the custom officers, the police officers, on how to spot the
infringing goods,
those who are infringing goods and all. I'm very curious here. So, back again to our booking industry, we seem to have a lot of pirated books in the country.
That is true.
So I'm very curious. How do you go about this, and what are the penalties? Like, for me, as someone who maybe don't know the difference between a pirated book and the original one, I go to town, I see it on the shelf, I pick it up, and I buy it. what is the ramification that if I'm caught with that, I would have to settle or deal with?
Okay, you are the buyer. You had no way of knowing that it was a pirated book, because with technology now, the pirated books don't look inferior.
Yeah.
At first, you could see double images and other things, but now it may even look better than the original.
I tell you.
They can pirate and go to India and bring it. So you can imagine. And with this, we even attempted to meet booksellers on the issue. We did meet them a number of times, and their complaint was that sometimes they don't get the books on time, and then demand is exceeding supply. So they are tempted to go and reproduce the books. That it was out of ignorance that they were doing it. So they would put a stop to it at the time. But there are those who also bring them from outside, who are not in the Booksellers Association, and they don't know that. Some know that it's wrong. You know that the book is not yours and you are duplicating. So what happens is that we have a copyright monitoring team. It's part of enforcement unit, which goes out and does raids. At first, we were really raiding quite often, but then we decided to resort to more education, because most of the people seem not to know that they were involved in infringing activity. So it began with the CDs. A few years ago, some people went to jail for 4 months for selling it. They didn't import it, but they were the ones selling it, and they were caught red-handed with.
So is it written in the act
the section 42?
If you there's someone who trade in such things, you
yes,
get 4 months?
Section 42 states all the offenses, anything that you do or allow someone to do, even if you are not the one who did it. Maybe I'm the big gun, I give money, I import containers of infringing works, 10-in-1 movies and all that. Then I'm the one who is causing that work to be done, and if there's an arrest, I will be arrested.
So is it only in prison term?
Well, no, if you look at the law,
fine,
there's a fine.
Prison term or
How
both,
much?
depending on the severity. Okay, that's why I said we're reviewing the law, because the how much is too small now.
Yeah.
Because even if it's 5,000 penalty,
It's between 500 to 1,000.
Yeah, 500 to 1,000. But
Penalty
one
unit.
is 12 cedis, so it's not that much.
Yeah.
A pirate can actually put aside the fine and continue with his misdeed. Yes.
So I'm
So
excited
the
you are
books-
reviewing that part, because
Yes,
I wanted to
yes.
talk about it.
Yes, really.
But I really want to hear your opinion about that,
Because the
you
maximum,
have-
okay, like you said, the maximum is 12,000. So if you are caught, because it's
can
between
just pay and
500
go
penalty units
and
to 1,000 penalty units.
And who
Or
determines
The
which
judge,
one
the
The
law is at the
judge,
bosom
yeah,
of the judge.
Okay.
So also there's another punishment, which is a criminal part, where you can go to jail for at least, or at most actually, 3 years.
3 years.
Not exceeding 3 years. So you realize that when she mentioned 4 months, you were asking whether the law says 4 months.
No, it
So-
was the judge that decided.
Yes, so the judges decide.
Severity.
So 12,000, assuming the judge even decides to give you the 12,000 plus 3 years in jail, it shouldn't be enough protection for copyright or any intellectual property right. Yeah.
Then
With the books, we had instance of destroying a full room of books that were infringed, and people who saw it, they were pleading that it be given to the less privileged and other things. But the argument was that if you allow these books to enter the channels of commerce again, you'll be surprised. People will take them, go and sell them, and then it will actually be in bad faith because of the original owner's reputation. If they see that this book is of a poor quality, and they will decide that I won't buy from your company anymore because I see that your books are no quality. Maybe it's not coming from there. So in order to avoid all that, they were banned actually, so that nothing would remain for you to sell.
I'm glad you brought up the banning of the whole place that has the books, because we are in an era where majority of readers or people who love books are gearing towards
E-books,
digital books, audiobooks and all. How do you then make sure that, because it's quite easy to get access to illegally downloaded books.
Yes.
So how then does the Copyright Office plan to get all these people? Because are you going to be in people's rooms?
No. Actually, that's an interesting question, because it's a very recent development. We've been in talks with the CID, the Cybercrime units. So that's still ongoing. It's not a code, so I can
Yeah.
talk about it.
Yeah.
But yeah, so we're looking at how we will liaise to get into those places, because in other jurisdictions, if you put something out there and it's not yours, the copyright owner can have you taken down. Your site will be taken down. You can't use. They will warn you 3 times. By the 3rd time, your site will be taken down. The internet service provider will no longer provide you any services, and then you'd have to go and start again from another site. So we're looking at getting to that, because this is the era in which we are. We can't go around collecting physical books anymore, because very soon we will also even be accepting only the electronic. We need to do it alongside, just for the benefit of those who will not be able to submit electronic copies. But we're already started, so it's running alongside.
Okay.
Yes, so burning, it will be out very soon, and then getting into the sites to monitor the use of the works. That's where we are at now, so that we can do all the monitoring. Wherever there are illegal sites, they can be taken down and so forth. But it's a gradual way forward, but that's where we hope to get to.
Okay, I'm curious, Mr. Beja, what will you do if tomorrow morning I get up and I send you an ebook of your own work? I'm like, Charlie, I just saw this ebook, you must read. Like, what do you know the steps you would take to sue me, or like,
Yes,
what are the
that would
steps?
definitely just, I mean, the same thing we're talking about here, breaching my copyright. I mean, my property that I have sole right to actually either to reproduce or to put out there in that manner. You have breached that. So, and like I said, the law, the 10,000 units is too small. Okay, I mean, not even 10,000, 1,000 is too small. So if you make me lose money in that manner, if, like the case of the Goethe-Institut, together with the Morgana J.
But that's hard copy.
Yeah, that's hard copy. That's what I'm even saying. So in that case, where somebody lost money because you put out something that was actually going to be contracted in that huge quantity, the same could happen to me, that I am making money from my book, maybe as small as it may be, on daily basis I am. But the moment you put it out there, I no more make the money I used to make from the hard copy. So you have actually cost me some loss. So definitely it should. So now the question again is, how does the court even quantify?
Yes, because what if I'm just a sharer?
Yeah.
I can easily come back and tell you, I was just trying to alert you.
The traffic on the website where you
Yes, to see.
all that can be used to assess how many people have actually been there.
Downloaded
It can safely be assumed that if you've gone to the site, you've downloaded it, and that can be used in awarding of damages to you. But let me use,
Can I play the devil's advocate?
Okay.
Tell us.
So we keep referring to sites, websites, but it's very common these days to share files via WhatsApp.
Yeah.
Yes.
And most of the time, WhatsApp is a third-party app, so it is protected under privacy laws.
Yeah.
So then, it's not really a site. It now comes to
go
a
to.
Social
personal
media.
communication,
Yeah.
social media mode of transfer. So how then does the Copyright Office tend together? Because then it becomes something that is a bit beyond.
The cybercrime unit,
Yeah.
they have access to all these things.
Yeah.
They are able to trace this. That's why we are looking to go into the partnership. We've already been there, but it's not concluded. So
Okay.
how to get into all that, because that is what's going on now.
Yeah.
But just a note of caution, it could be 2 ways. This one, you found it and sent it to him. But there are other times when somebody puts out his own work and then other people take advantage of it. Let me give an example. It was an artwork. And the person wanting to publicize himself put it out there, but he put the best quality out there. So before he knew it, somebody had taken it. Actually, he was dealing with someone outside, and the person said, send me a snapshot of your artwork. And then he gave her the best quality one. And then before he knew it, it was on a site where it had been priced, and people had been buying and buying and buying. But in this case, the mistake started from him giving her that copy. You would just have to give a low resolution version of it, and maybe just a little, don't give the full size, so that the person cannot exploit it.
Exactly.
If once you expand it or you zoom it, it will pixelate and you can't use that.
Yeah.
So just, if you have something you need to give out, if you're giving out a document, I know PDF can still be breached, but put it in a way that the person cannot get into it and unuse it, alter it and use it in a way that affects you. So just moral rights. I'm sorry to put this in, but a lot of people don't realize that they have moral rights in a work. So once they get paid for the work, even if you're a writer,
Yeah.
it's a recent problem yesterday where somebody brings a book with his name on it, but we all know he didn't write that book. He paid someone to write the book. And he said, oh, after I've paid him, but the person's name must be there of necessity because that's the moral rights of the person. You can claim the copyright ownership, but you can't claim the authorship, the fact that you wrote the book. So we need to be careful not to give out our rights like that. We have to always retain the moral rights that we can object to how the work is used.
Okay, so this has been a very fruitful conversation so far. I find myself enjoying the various angles. I would like to state that I would want to follow up on your partnership with the cybersecurity. I'm very curious about that. So definitely following up with that after. So in wrapping up, how do like anyone just on the streets walk to your office? Like, how does it work? How does one go about registering or securing their intellectual property?
Okay. With copyright, you can just walk in, or you can delegate someone to come and do it on your behalf. All you need is to give your ID or a photocopy of it, to the person with 2 copies of the work in question. And the prescribed fee, the fees vary depending on what you want to register. So if it's a book, it's 50 cedis. If it's music, it's 40. If it's an artistic work, it's 70. If it's an audiovisual, 70 as well. Then computer software is 160. So you come in with 2 copies of your work, a valid ID card, the prescribed fee, and then we will take information from you concerning the work. When was it done? So, like I said before, coming first doesn't make it yours because there's a column for the year in which the work was completed. So if you wrote it in 1996 and you're now registering it today, there's a column where you can write that you finished it on this date in 1996. And so that is the true date of when your work was done. So we fill out the forms for you actually, so you don't have to write anything down. We just take the information, it's typed out. We give you a copy of the forms to take along, and then in a month you come for your certificate and you're good to go. But meanwhile, you can use your work. You don't have to wait until the end of the process before you can go ahead and do what you need to do. With industrial property, you contact the Registrar General's Department. I must say that they've moved that section to the industrial property section to the Ministry of Business Development, first floor. It's now called the Ghana Industrial Property Office. So they will take care of the patents, the trademarks, the industrial designs, geographical indications, and any other industrial property that you have to register.
Okay. So where is the office again, the copyright office?
The copyright office adjacent the Teachers Hall in Adabraka in the Workers' College Enclave. So it's right next to the Ministry of Information or the Regional Coordinating Council, that area.
Okay. So we can find it
so
on the
you
Google map.
You can find it on the Google map.
All right.
Yes.
All right.
The name is boldly written on the building, so you can just see it upon approaching it.
Okay.
Yes, and you can also find our numbers on our website. There are 4 mobile numbers that are available to be called.
And they all work.
They are the staff numbers, including my number. So no matter where we are, it's a mobile number, so we're able to help. Yeah.
That's good. Mr. Bedra.
Yeah.
I've seen your book, right?
Yeah.
Have you registered it?
Oh, yes, I did. I actually did this in 2011, and I think in 2012, I caught someone selling my book without my knowledge.
Wow.
We went to court, and along the way, I had to just leave the case, So I was happy I did the registration because when I went to court, I was able to produce the certificate. That was why I said that in as much as it is not compulsory to register your work, you have some level of more protection or extra protection when you register the work. But to quickly add before we go, it has been established here, even by the law, that ideas are not covered by copyright law. So the practice of sending your books in soft copy to people to look at, to edit, to work on for you, you should be very careful. What it means is the person can adapt the book. The person can even get a central theme in the book and publish it before you. Now, when that person does that, what it means is the person is now the one with the copyright over the document. Because these cases have always been determined even in the United States Supreme Court, where in the case of Donokio versus Allied newspaper, it was established that when you go and discuss your idea with an author about a book, do not forget that the moment that person comes out with a copy of the book, you are no more the one who has the right over it. So you can't go to court. Okay, so let us avoid discussing ideas. Well, I have a story, I want my storyline to go this way. Now, that idea is what the person can pick and develop. Because at the end of the day, the story, he may not write it the way you want to write it. But the moment that idea is out in his book, what it means is that you can't even write it again. Because it may not be unique. It doesn't have the uniqueness that you would want to come out with it. So let us advise the writers, I mean, anyone with intellectual property, especially when it comes to giving it to a third party without even agreements. Let's be very careful.
And more so in the industrial property sense, giving out your work without, I mean, once you explain your work or you discuss your work, especially with the patents, if you discuss it, you've defeated the whole aim, because nobody should know. So in trust, you are disclosing all the information to the office that is protecting you, which is the IP office. Is protecting you. You are giving them all the information needed in exchange for that 20-year period. So if you tell someone, you've already violated the patent registration.
Yeah.
So you need your first port of call, maybe your patent attorney, who is going to draft the document for you. And that's it. Even that, you should have an agreement with your attorney, because he may also be tempted to do something untoward. So you have to be very careful when you're giving out your stuff and when you're discussing, especially with industrial property, because first to file, if even the lawyer decides to swindle you after drafting it and he hands it in as his, it will be given to him. And so it's very important that we take note.
Okay. So this has been a very enlightening discussion, and I really want you guys to stay here and keep talking and talking. But time is not on our side. So in wrapping up, can we have concluding remarks from the two of you on how to secure our intellectual property, whether we are in the book world or we are just the industrial property world. I like that word. Okay, so a few tips. It's important, either as an individual or as a company, you identify the property that you have, intellectual property that you have. You have to first identify it, find out the way that it can be protected, and then go about the protection, put in the applications. If it's a company, get someone whose schedule it is to follow applications, payments, renewals, because if you don't renew your trademark and it's 10 years, somebody else can register the very same trademark and use it for something else. And for authors, if you write a book, please, even if you sell it out, your moral rights is still yours. It never goes away. Your name must always be on the book. Never agree for your name to be taken off just because you've been paid for the work. If you do an illustration for someone, your name must appear in that book as the one who did the illustrations. Everybody's rights must be acknowledged. And for those who are just engaging in illegal activities, it's a note of caution. Maybe today you're getting away with it, but very soon you won't be able to. But just consider it this way, that this is the means of livelihood of the author or the creator. And so by taking it and selling it illegally, it's just like stealing, really. And so you consider the interest of the person who created it. This is the means by which he would eat. And therefore, if you take it, just consider your fellow man that this is how he also survives. And therefore, if you take what belongs to him, you are cheating him unduly. So use the humanitarian side so that you can also feel for your neighbor and you don't do the illegal activities. Thank you.
Yeah, so like Thomas Jefferson once tried to make the point concerning intellectual property, he made a point that when you share your idea with someone and the person likes that idea, it doesn't lessen your idea that you share with the person. And if the person also goes on to put that idea out, it doesn't darken your idea. That goes a long way to make the point about the fact that intellectual property, in as much as is one of the properties we hardly talk about, it is in fact the most expensive property we can have. If not for anything at all, some of the most wealthy people in this world are persons who own intellectual property. So the likes of Mark Zuckerberg and all that. So it is an industry that you do not have to look down on. And being the reason why you have to look at the protection that comes with it. And you also don't have to joke with it. Because what can make money for you and turn your life around could be taken by someone if you do not protect it well, and that could be the end for you. So, like I said earlier, for me, my concern, again, is that when it comes to sharing your works with people, be very careful who you do that with. Because like the law will tell you, it doesn't protect ideas, it doesn't protect concepts and procedures. So if you send your book through mail to someone and the person decided to pick the whole book and even publish, you take the person to court, you may not win. So be very careful how you share your work and who you share your work with to look out for you, especially when it comes to literary works. Yeah.
Okay. Ms. Jama,
Yes.
Mr. Bedra,
Yeah.
it's been an honor having you here.
Thank you.
Thank you
you for
so
having
much
us.
for coming.
Thank you.
We are grateful. We are very, very grateful. And to those who have been watching us, I hope you took some notes, because for me, my head is already reeling with this information. Thank you. We thank you for watching. We thank you for staying tuned. We hope to do this with you again.
Thank you.
In the meantime, please mask up, stay safe, and read more books. Bye.